This is the Decibel and Docket podcast. So, Mike, this week, before we start off, I've got something to confess to you, buddy. I'm not playing at full strength this week. I have a tongue injury.
No.
Man, I wish there was a cool story behind it, but it's just basically I cut my tongue on a dental issue. It's not a cool story, but a kind of a painful recovery. I'm having a difficult time talking, but I'm managing. I will tell you, it's interesting the friends who call, and when you tell me you have a tongue injury, those who understand when I get the phone quickly, and those who just don't give a shit, just keep talking.
Dave, this shows your commitment to the Decibel and Docket listeners, that you're here, you're pushing through. This is what this is all about, is giving our listeners the news that they need.
Couldn't agree with you more, Mike. What you're saying is so right on. So let's, maybe we won't make a big a deal about it this week. Maybe I can't say it with the same fanfare I normally do, but let's roll the intro.
Let's go!
Welcome to episode 31 of the Decibel and Docket podcast, the podcast of the intersection of the music business, live entertainment, and the justice system. I'm Dave Brooks, veteran entertainment journalist and longtime touring reporter covering the concert business.
And I'm Michael Seville, an attorney and avid fan of the live entertainment industry. As a former journalist and now practicing attorney, I hope to shed some lights on issues that insiders may not be looking at, nor maybe do they want you to look at. And we'll cover all things that go on behind the ropes, as they say, in courtrooms, in boardrooms, in negotiations. And look, I'm not soliciting clients. I'm not your attorney. I'm just here giving my opinion on some of the hottest issues in the entertainment space. And I'm not going to make fun of Dave today because, you know what? A tongue injury sounds super painful. So no jokes from my buddy Dave Brooks, who is a champion and pushing through here today.
It is not fun, let me tell you that, my friend. Well, you know who else is not apparently not having a lot of fun? Ellie Goulding's old managers at TAP. This week we're talking about Ellie Goulding's lawsuit against her managers at TAP, the ones she hired to guide her career. How is it possible that she didn't realize that they were owned by Live Nation Entertainment?
Well, that's a good question. And I think we're going to get into the required disclosures and those kinds of things. But it's a pretty interesting story that kind of raises more questions than answers for me at this point. But yes.
Same here. Sometimes I think, wait, is this the real antitrust story, with Live Nation? But before we do that, we've got an interview with show regular Randy Nichols to talk about the death of his beloved AB 1720, the California Fan's first act, which died in the suspense file in the Senate, the California State Senate, I should say. Mike, first of all, forgive me as I apply oral gel to my mouth through this interview.
No problem at all.
But Mike, I've never heard of the suspense file before. You're you're the ultimate Sacramento insider. You know that place better than most, better than me certainly. What does that even mean to be put in the suspense file?
Yeah, so suspense file is a tool that the fiscal people in Sacramento use to slow down bills that carry a cost to either the general fund or a special fund.
Okay.
And any bill that costs more than $50,000 to the general fund has to go to the suspense file. If it costs $150,000 to a special fund, it has to go to the suspense file. But in reality, what happens, so every bill, almost every bill, because every bill seemingly costs more than $50,000, goes to the suspense file. And what that means is it goes to the Fiscal Appropriations Committee subcommittees for fiscal analysis so that it adheres to the budget, or that the budget knows what the real cost is going to be. So it's not unusual. It's very common for bills to go to the suspense file. But what actually happens once they get in there is, where the myth, the legends, the hyperbole kind of starts as to why does some bills get out of suspense and some don't, and why is it somewhat considered like the graveyard for unpopular or politically touchy bills go to die. So I mean that's really kind of like where the 1720 story kind of goes and unfortunately ends for Randy and everyone that was really supporting that.
Well, let's talk about the bill for a second. As you remember, the bill originally proposed a broad ban on reselling tickets above face value, but after months of amendments, it had been narrowed considerably. I think, interestingly, it would have only applied to venues with 3,000 seats or fewer, and allowed resale up to 10% above face value. So this thing was no longer going to affect arenas or stadiums or large theaters. It's really affecting clubs and small theaters, right? But even that was too much for StubHub. The company spent $3.4 million lobbying in California this year to defeat it, including $2.6 in the last quarter. That reportedly made StubHub the second largest corporate lobbying spender in the state in that period, behind PG&E, our embattled electric utility company here in the Golden State. Ticketmaster, meanwhile, spent about $91,000 supporting legislation. So interesting ROI there. But the most consequential player in the story may not have been StubHub or Ticketmaster. It may have been California Attorney General Rob Bonta, a reoccurring character on this show. Sources tell us that Bonta's office raised concern with key staff about the cost of enforcing this bill. One source, as we talked about, Mike, says Bonta believes the estimated costs were either off or approaching $1.4 million. That fiscal objection gave the Senate Appropriations Committee a reason to hold the bill on a suspense file, effectively killing it without requiring senators to cast a public vote. Now, there may have been a legitimate funding problem with the bill, but the more interesting question is why Bonta chose to intervene against legislation that was designed to protect concert fans, and why he did so while leading one of the most consequential antitrust cases in the history of live music business. We're talking about the Live Nation Ticketmaster antitrust case, which Bonta helped lead with the help of private counsel Jeffrey Kessler. If that breakup happens, and that's what they're pushing for right now during the remedies phase of this antitrust trial, the government will still need viable competitors capable of taking on divested contracts, technology, or other Ticketmaster assets. And the list of buyers is not very long. It potentially includes Access, CTS Eventum, SeatGeek, and depending on how you look at it, StubHub. StubHub's lobbying argument was essentially this: you can't spend years accusing Ticketmaster of monopolizing the ticket business and then pass a law that potentially cripples some of the few companies capable of competing with it. Mike, what do you think of that argument? Do you think that's why Bonta moved against the bill? Because there's this larger fight to be had with Ticketmaster?
No, I don't know. Like why and how Bonta got involved in this, I think is a really interesting question. And given his very public support and legal participation in the Live Nation Ticketmaster case, like I don't think anyone can say that Bonta's not all in on antitrust practices by large companies. He was one of the first to come out and write a letter about the World Cup and seeking information from FIFA about the ticketing thing. So like, I've worked in Sacramento.
He's also leading the fight against the Paramount Warner Brothers.
Right. So I don't really buy that Bonta chose to kill this bill, whether or not he could. I mean, like, there are so many different factions in the legislature. Haney's bill was really, supported by the independent venues. I think, he might have been looking at enforcement problems or concerns around 1720. I think, like when the legal team sits down and looks at a bill, they have differing opinions of how difficult, or how much money it would cost to actually enforce it. And whether it was enforceable at all, I think is a question. There was probably going to be appeals and challenges to the bill. And so Bonta might have just been playing the long game here. And I'll get to my theory on that a little bit later in our conversation. But, I don't know. I'm not sure Bonta moved against the bill per se. I think he probably raised some pretty legitimate questions about the cost, looking at like what enforcement of the bill, especially, and people have to remember, when the bill goes in and it was amended so many times. So an original analysis of Matt Haney's bill changed significantly, probably got a lot cheaper, to your earlier point, Dave. Like, at its last stages, it was only targeting, venues under 3,000, 10% price cap. So it arguably might have gotten cheaper and easier to enforce in terms of volume. But there probably were some challenges to it. So whether or not Bonta moved to kill it, what kind of, horse trading, so to speak, what was going on in the suspense file with other bills, other priorities of the legislators. Like, Bonta doesn't have a vote on this. Like, like it's the senators and the assembly members that make these decisions, and what happened, and why this bill passed and the other bill, which we'll comment on in a little bit later, did move forward, is all why Sacramento is what it is.
Well, let's do the most basic question, okay? An attorney general is generally thought of as the state's chief consumer protection officer, right? Here you have a bill explicitly marketed as consumer protection, and Bonta's office reportedly helps stop the bill over enforcement costs. Is that inherently contradictory, or is scrutinizing whether a law can actually be enforced part of his job?
Well, I think it is. It can be contradictory, just to be blunt about it. It seems contradictory on its face, but again, the practical efforts of enforcing that bill might have just been too much, and with the amendments and why Bonta thought it would cost more than what Matt and the legislation originally was costed out at. There's a discrepancy there. And let's put this in the macro context. I mean, California is facing huge, crazy deficits right now. First day of school in Northern California is happening this week, and all the schools, the funding for schools are drying up. So you get down to pinching pennies, and $1.4 million or whatever the final price tag doesn't sound like a lot. It sounds like a lot of money to me and to you and to most people listening to this. But when you're playing with every single competing interest, every single bill, how are we going to make this work? The budget has to be balanced. And there's probably a lot of reasons why this went down the way that it did, despite Randy's and everybody's best efforts trying to get that bill across the line.
Right. I mean, you mentioned that, and that, this number, right, $1.4 million, sounds like a lot of money, to me, but California's budget is measured in hundreds of billions of dollars, and StubHub spent $3.4 million lobbying against the bill. Does the size of the alleged funding gap make the enforcement objection more credible, or does it just make it sound like a convenient procedural tool for killing legislation?
I mean, again, it's both.
Okay.
Because this bill had to go into the suspense file, and every other bill that meets these fiscal thresholds go in there, we have to just talk about the fact that AB 1349 was in there as well. It was a ticketing bill as well. And so when you start looking at this, I've not talked to Bonta about this or don't know his thinking, but if he was involved in having conversations and raising concerns about its enforcement, and maybe some legislators take this opinion too, it's like, let's see how the Live Nation Ticketmaster antitrust case actually goes in federal court. Let's pass 1349, which got rid of phantom accounts and really kind of
Other
targeted
legislation, yeah, right.
the
That's
other bill.
the
Sorry,
bad
AB 1340.
behavior.
Yeah.
Yeah.
Let's see where the Live Nation Ticketmaster landscape goes in the federal court. Let's pass the anti-fraud bill, AB 1349, which targeted speculative ticking and bots and things like that. And then let's see where we're at in another legislative session in a year or two after the dust is all settled, and then see if StubHub is right. StubHub is making the argument that, hey, dude, you're breaking up Ticketmaster, but you're going to kneecap some of the competitors that are supposed to fill this competitive void that a breakup with Live Nation and Ticketmaster might create. Don't nail us before we have an opportunity to fill that anti-competitive kind of space that you're seeking to create. And that's what happens. And quite honestly, I had a bill one time that a governor who will not be named, and it was not Gavin Newsom, I'll say, told me he was going to sign, didn't sign it. It died. I took it there twice. And these things happen to a lot of bills. A lot of bills die in weird ways in Sacramento. And it's super frustrating when it happens, but sometimes there's a reason.
Well, let's look at this idea though, okay? Right, about the monopoly idea, right? Breaking up a monopoly, right? It sounds simple. It's Bonta's political slogan, but I mean, it is a fact that if Ticketmaster is forced to break up, it loses venue contracts, divest technology or other assets. Those things have to go somewhere, right? So could a remedy, actually fail, or at least become much harder to administer if the marketplace lacks financially viable alternative ticketing companies to pick up whatever Ticketmaster is shedding?
Yeah, I mean, I guess, yeah. I mean, so I guess the answer is yes. But if there truly is a competitive marketplace and there's a need, other companies would step in to fill that void. Companies that don't exist now, companies that do exist would, that kind of play in the space could fill that void. So I'm not sure that StubHub's argument is super sound on that, but I get it. But legislative and regulatory actions that do create competition, that space gets filled with competitors. I mean, if there's an actual need and demand for companies to service that particular space. So I'm not sure I really buy StubHub's kind of take on that.
Fair enough. Well, I tend to agree with you. We had one during the last process when the two companies merged. There was plenty of competitors to help offset the merger of Live Nation and Ticketmaster. With Access, Pacquiao, two of the companies, right? Here's a more broad legal question, though. Okay, AB 1720 would have imposed a price cap on resold tickets. I'm not sure if that's legal, to be honest with you, right? Especially in a capitalistic country like the United States. I'm trying to think of something comparable where we've banned resale markup on something else. We don't have on automotive, on clothes, not even on land or real estate, right? If opponents likely would have challenged AB 17 if it became law, potentially on constitutional grounds, interstate commerce grounds, or federal presumption arguments, Bonta would have possibly had to defend it. So could he have potentially killed the bill knowing that it was difficult to defend and he didn't necessarily want to expend the capital to do that politically or financially?
It's possible. And I think there is probably a real concern with a legal challenge to government created price caps. I mean, if the government were allowed to do that, why do we spend so much on medication?
Exactly.
So the government, does not get involved in the market, or it's not supposed to, I'll say,
right.
Outside of anti-competitive and some other kind of more specialized areas where the government is more involved. But why do we pay so much for gas? Just because of things going on in the rest of the world. Why do we pay so much for electricity and natural gas in our homes? It's because the government doesn't really get in there. Actually, natural gas and electricity is a regulated industry, so that's a bad example. But, governments don't do that. And I think Bonta is probably right if he was considering this, is that he would be tasked with defending this bill. And maybe, there's not a strong enough legal argument to support it, and they want to see what happens with Live Nation and Ticketmaster case, and see what this anti-fraud bill, if it can make a dent in some of the high prices and kind of fraud that's going on in the ticketing space again. I think that might be what's going on, though. That's just my opinion sitting here with my dog.
Well, let's I'm gonna go ahead and kick it up over Randy, who I interviewed earlier this week. Of course, Randy was closely involved in creating and helping advance 1720 with Matt Haney, and he joins us now to explain what the bill was originally designed to accomplish, how it was gradually narrowed, what happened behind the scenes in Sacramento, and why the role he believes Rob Bonta played in killing the bill. Here we go. Take it away, Randy. Randy Nichols, Decibel and Docket podcast. Welcome back to the show, my friend. You've been on some travels we were talking about.
Yeah, thanks for having me. It was nice to go see the total solar eclipse off in Spain last week. Pretty freaking cool.
Yeah, that sounds incredible, man. Well, while you were away, I think AB 1720, Matt Haney's bill in California, died a death befitting of a powerful piece of legislation, in that it mysteriously died in the middle of the night, with difficult to trace what killed it. I kind of think, having been around for a while, the more suspicious and fingerprintless the death, the more dangerous the bill, because why would somebody care about killing something that didn't matter, right? So of course, this is the legislation in California that would have capped resale at 10% of face value. It had quite a life, having put through multiple committees in the state legislature, especially in the assembly. It goes to the Senate Appropriations Committee in California, and then it's dead. What the hell happened? Any ideas?
Yeah, so, basically we were shocked we got it as far as we did.
Uh-huh.
The bill was what they call triple referred in both the Assembly and the Senate, which means a lot of bills, it's like, okay, we all agree, let's vote on it, move it forward, and have the floor vote. Every obstacle that was humanly possible was put in front of us. And every one of those rounds, nobody believed that we would get through that round. And some of it, I think, comes down to, we presented a really valid argument as to why this law is necessary. But going against this, we had about $4 million spent by StubHub to kill this bill, to hire high-priced lobbyists to convince them that this bill is bad. Almost every California resident got a mailer in the mail, a physical mailer, telling them not to support the Ticketmaster bill, which couldn't be more of a possible lie. But basically, these politicians, they knew that, they didn't fully understand. They knew that, it could help Ticketmaster, it might not. Different people were saying different things, but nobody publicly wanted to kill it. But the second it went behind closed doors and there's no one watching, it was real easy to kill, and not a lot of people willing to stand up and protect it, because all this money that was spent convinced them that it was possibly the Ticketmaster bill.
Right. Now, I have a dominant theory in this story, that it was California State AG Rob Bonta who killed it. The simplified version of the story goes, he basically told the Senate Appropriations Committee staff people that it was going to cost $1.4 million more than what they originally thought it was going to cost, and that was enough to kind of kill the bill. because that big of a disagreement between cost and implementation, usually does kill these type of things. And Bonta right has kind of complicated political reasons why he would probably maybe be interested in killing the bill, which we can get into. But what's your read on that story?
Yeah, so I've just learned more than I'd ever like to learn about the government over the process of this bill. And there's lobbyists that people pay simply to work attorney generals. And
Right.
they spend a ton of money to miseducate and pressure Attorney General Bonta on this issue. And he stated this $1.5 million that you brought up is $1.5 million just to study how this bill would be implemented and whether it would work or not.
Right.
And that's StubHub, who's spending millions of dollars to get in the way of everything, is basically saying we're going to spend a ton more money to cause problems. So it's going to cost you to do the right thing because of all the money we're spending. And at the end of the day, the consumers are hurt. The attorney general is just following the scalpers in this. And the argument that they've presented, the scalper community, predominantly StubHub, is that there's pending litigation against Live Nation Ticketmaster. And until that litigation has been completed, there can't be changes to the ticket industry.
Right.
But the facts of the case are that there is literally no area of the Live Nation Ticketmaster monopoly trial that touches on secondary market ticketing.
Right.
And to go a step further, StubHub does not offer any primary market ticketing products. They don't offer a box office software. They don't offer access controls. They don't issue primary initial offerings of tickets. So they stood up there, and I stood in the room and listened to them testify, and they stood there and lied to the legislators and said, if Ticketmaster gets broken up, that this will help StubHub to become a legitimate competitor. But the truth is, as we all know, working on our side of the business, there's a bunch of legitimate competitors to Ticketmaster, and StubHub is not one of them. They don't offer those services.
Right, exactly. And I think it became ultimately easier. I think that one of the things we kind of learned on this, though, is that, look, Rob Bonta is very invested in the antitrust victory over Live Nation, right? He's not as invested in this case, right? And I think perhaps, that was maybe, do you think it was an oversight not to bring him in earlier on this? Or I mean, what's your kind of postmortem on the lessons learned here?
Yeah, I mean, we've known that we needed to get Bonta on board, and he and his staff truly believed that this was going to help Live Nation Ticketmaster. This is publicly, I'll share this, but off the record, like no one wants to talk about this. We reached out to people involved in the trial for Live Nation, against Live Nation, the prosecutors against them. And we spoke to varying people involved, and nobody would fully go on the record about this, but we wanted them to go on the record so we could use it for Bonta. And ultimately, what all of them said was, this is pending litigation and we can't discuss publicly, but look at the trial. Look at what the facts of the trial are, and you will find your answer. And the facts of the trial are they're not in that business. So we couldn't get these people to publicly speak out because they don't want to be weighing in on another case that has nothing to do with them. But they pointed all signs to what the truth is, but AG Bonta just didn't seem to want to get involved and address facts. He's, just looking for as big of a win as possible on the Ticketmaster case. And this isn't his case, so he's kind of indifferent.
Have you talked to Haney? How's she doing?
Haney's ready, and I haven't personally talked to Haney, but from what I understand, Haney's ready to go to war again next year. Like this.
Okay.
he's not stopping. Like, he knows that this is right and will continue fighting. And we're also, working on the federal level. Like, there's legislators like Blumenthal from Connecticut who were always kind of carrying the water for the scalping industry. Blumenthal's from Connecticut, where Ticket Network is based, which is one of the largest original ticket scalpers. And he was siding on their side, and he publicly stated recently in a hearing that there should be a resale cap. So we're hoping that folks like him are going to get on board. And, we also have Representative Garcia from your district in Long Beach, California,
right,
who sent a letter to the CEO of StubHub demanding answers to all the sketchy things that they're doing. So at the federal level, there is an interest to take this up this fall. And I think we'll see the fight turn to there. And, we'll see, what StubHub spends there will be dwarfed, will dwarf the California spend. And to give you an idea, like, they spent so much money in California to kill this bill that they mentioned it in their earnings call that their spend on regulatory lobbying was, significant and impacted their bottom line.
Wow.
But that tells you everything you need to know. Like, they're worried about their own survival.
What about other states, right? This is still an issue. And it passed in D.C., and Massachusetts has talked about this too, right? I mean, what are the other states that are ahead for this law?
Yeah. So Massachusetts, we're still waiting this year. Massachusetts is now in the exact same spot that California was, with the exception of we don't have an attorney general trying to kill this, which is fascinating because this attorney general there is also a party of the Live Nation and Ticketmaster case, where he is against company, thinks there should be a breakup, but doesn't think that StubHub has anything to do with it. So Massachusetts, though, right now, there is a committee of 4 legislators who are deciding what bills will make it to the final law. And there's behind closed doors once again, and StubHub is spending a fortune to try to fool legislators, while we're trying to use musicians to call and speak to legislators to educate them. And, we think we have a really good shot at getting this passed in Massachusetts still. But, you've got people who spend millions to tens of millions and straight up lie on a regular basis. It's hard to beat that.
Yeah, right. It's hard to beat that, but it seems like you definitely have kind of gotten StubHub's number here, right? For the first time. They've been doing this to Ticketmaster and other companies for the longest time, right? They're the ones who have been kind of legislating by proxy against, things like paperless tickets and resale restrictions, and now they're the ones being put on their footing. My last kind of question is: it seemed like StubHub's been seriously weakened by what you've done?
I wouldn't say it's so much of what I've done. It's the music community banding together and fighting back. And a lot of this goes back to the Save Our Stages grant, where the entire music community began working together as a group. And in that process has built relationships with legislators. So, we are making a difference. Clearly StubHub is scared when you look at the amount of money that they're spending to fight back. But, you're fighting this massive monster who has no problem lying in testimony, lying in marketing, lying in ads, spending money to fool people, doing sketchy community work. Like in New York and California, they ran a program to give away $100,000 worth of free concert tickets and sports tickets to kids. Like they're coming up with any storyline to show that they're the good guy, but it's clear that they're not.
Right. Well, it'll be interesting to see kind of where this picks up next fall. Do you think that Matt Haney reinitiates legislation at the beginning of the year, or what happens in California?
Yeah, so I'm not 100% sure how the California legislative process works. They, some states have a 1-year process, some are a 2-year process, but I think we're heading into a new session next year.
Yeah.
So I'm hoping that he's going to reintroduce it. He seems to have the stomach for doing that. And hopefully on this reintroduction, it will be after we have a handful of more states that have passed and, a couple of more studies out. There's a new study that should be out by the time this airs that's from a consumer rights organization that's pointing out the numbers and the lies in StubHub's math. And, we'll talk about that one when it comes out as well.
All right, awesome. Well, man, thanks for being back on, keeping us up to date. And sorry about this one, but I'm sure, there's plenty more fights ahead.
Thanks.
This next story has got everybody talking, Mike. Ellie Goulding, are you an Ellie Goulding fan by any chance? Or do you even remember her music?
Yeah, there's that one really catchy song. I mean, like, it's not
Lights,
music that I listen to like a lot, though. For some reason in the algorithm that my daughter listens to, that song pops up, and I'm like, oh, it's got a catchy little tune. I mean, I kind of like that song.
Totally, same here. She famously hooked up Taylor Swift and Calvin Harris. Of course, it didn't work out, but she's kind of a famous British it girl, I guess you could say. Well, her former our next story involves Goulding, her former management company, and a potential conflict of interest that goes straight to the heart of what an artist manager is supposed to do. Goulding has filed a lawsuit in the UK against her former managers Ben Mawson and Ed Millett, along with Tap Management's parent company, HNOE Limited. I'm assuming that's how you say it, HNOE. I know, otherwise I'm not sure. There's a wrong way to pronounce it. But the basic allegation here is that Goulding signed with Tap in 2018 without being told that Live Nation already controlled his parent company. Live Nation apparently acquired a 50.1% in HNOE in 2015 and bought the remainder in 2019. According to Goulding, Mawson and Millett ultimately reported to someone designated by Live Nation CEO Michael Rapino. Goulding remained with Tap until 2025 and paid the company a 20% management commission, which to me sounds kind of high. I thought, man, it was ranging between 10 and 20%. So it's like, God, during their relationship, she entered into agreements with Live Nation companies involving touring, merchandise, and a documentary film about her. But this lawsuit is about more than allegedly undisclosed ownership. According to Goulding's claim, Mawson and Millett were subject to contractual restrictions that prevented them from encouraging their artists to stop doing business with Live Nation companies. Basically, there was a clause in there requiring the Mawson and Millett to steer business to Live Nation. They were also allegedly prohibited from doing anything that might reduce or diminish an artist's commercial relationship with Live Nation or one of its affiliates. Think about what that potentially means, Mike. An artist manager was supposed to sit on the artist's side of the table. The manager is supposed to compare offers, negotiate aggressively, and tell the artist when it's time to walk away from a bad deal. But Goulding alleges her managers were contractually restricted from recommending that she walk away from one particular company, Live Nation, the same company that owned her management business. That creates an extraordinary collusion of loyalties here, or conflict of interest, as we might say. If another promoter, merchandiser, or business partner offered her a better deal, could her managers freely recommend it? Could they threaten to leave Live Nation during a negotiation? Could they tell Goulding that Live Nation was no longer the best partner for her? Or did their own contract Live Nation place a thumb on the scale before the negotiations even began? Okay. Right. Michael, let's start with the fundamental issue here, okay? What do you think a manager legally owes an artist client?
Well, I think they do or owe Well, let me stop and give you a legal answer first. They
Okay.
owe what is laid out and agreed to in the contract.
Right. Okay. Yeah.
And so knowing what's in that contract is really important. But yes, they do. Most contracts and most managers do assume a level of fiduciary duty that they will act in the best interest of their client. I mean, that's like pretty standard stuff. And so I would say that yes, they owed a duty to Goulding to get her the best deals, to get her the best touring dates, to try to make her as much money as possible. Like that was their duty. And if these alleged clauses impacted their performance of the contract, then that it could be argued, and Goulding and her legal team are certainly arguing that that's a material breach of contract and of their fiduciary duty to act in her best interest. Just one note, this case is filed in London or in England. And so there are different laws, and I certainly do not know the intricacies and complexities of UK law, but they're similar to what they are in the United States. So, I don't want to like speak out of turn and represent that I know and or practice law in the UK. There are similar kind of legal requirements and obligations owed in contract law in the UK and here. But I think almost anyone, and I don't know if anyone could say that, whether it's in America or in the United Kingdom, that a manager for an artist can legally not give that artist like the best advice or seek to like maximize the profits for that artist in under any like legal theory, like so my question, one thing that's really interesting for me is what was their duty to disclose this? And that's why I want to know it. Maybe it's in the contract. Maybe they already disclosed it, and she didn't read it, or whatever. Like I don't know. Like I want to know what's in that contract. Like how could she not know that company was bought by Live Nation or 50.1% of it or whatever, and that there were these anti-steering clauses in it, or steering clauses, depending on how you read it, that could have like really like impacted her to such an extent that there was real financial loss.
Right. Exactly. Because that's the big question here, right? I mean, it's like first of all, like you mentioned, how could she not know, right?
I mean, I think her argument would be it was their duty to disclose. And that's why I want to know, like, what's in the contract. Was it disclosed? Was it in the fine print? Was it on an addendum? Like, when did she enter that contract with TAP? And then when did the sale happen? Was it, like, did it happen after she signed with them or before? Like, what was the duty to disclose? Like, there's a lot of, like, kind of weird, boring legal questions about disclosure, and what's in that contract about that. And yeah.
What do you make of the fact that Live Nation was not named as a defendant in this case?
Well, she didn't have a contract with Live Nation per se. And so, I think there would be a question of standing and whether or not they were an actual defendant or not, properly named in a complaint. Because this was filed in the UK, I don't know what the pleading standards there for naming defendants. But you can't, they could be brought in later, at least in America they could. That's why most lawsuits include does 1 through 10, 1 through 50, 1 through 100 or whatever, because like there might not have been a sufficient amount of information to Goulding's attorneys to name them on the initial filing.
Right.
But they probably could and would seek to amend if they could get a bigger fish in a complaint if they had a factual basis for naming them as a defendant.
Now, Ellie Goulding has a very high-profile booking agent named Kirk Summer. It works at WME, right? And in California and other states, the job of booking agent is legally separated from managers. There are rules saying that one person the person who manages the person's contract cannot always be the same person who finds new business for her. Kirk Summer, if this arrangement was in place with Live Nation, wouldn't he have to know that? And what would be his responsibility to tell her? I mean,
Well,
that's what I'm
again,
trying to understand here. Like, where does Kirk play in all this?
right. And was he named as a defendant?
Not that I'm aware, but
Not me either. Me either.
This thing is hard to track down. Anything in the UK is difficult to track down because of the disclosure rules there.
Yep, they have much stronger privacy rules over there. But I think it's a good question. And if these clauses were contained, like the steering clauses, were actually in the contract, and she has a separate booking agent, which wouldn't handle all of it. It wouldn't handle like the merch and some of the other things that like are allegedly, steered towards like Live Nation affiliates or whatever. But like other people had to know about this for the contract to actually work. And like, why, what does this guy know about it? And why didn't he tell her? It's like, hey, we have to play this venue. Oh, okay. But what about the one across the street? Oh, we can't because, this clause in your contract with, that had to have, I think, probably come up, or people knew about this. I mean, it seems like they would. I mean, but again, who knows?
Right. And the question is like, look, I just checked it out. Like, Ellie Goulding has played competing events. She's played Coachella, which is owned by Live Nation, which is owned by AEG, the biggest competitor to Live Nation. She's played it 3 times, right? And so it's not like she's just totally missing out on opportunities, having to say no to opportunities from competitors, right? But when you look at the steering thing, the steering clause, it sounds like, when it came time, she needed to be steered. If there's a question, right? If Live Nation would be given first right of refusal, it sounds like, according to the thing, right? I mean, how can a management contract even have a steering clause in the first place? Like, it just seems to be antisma to what it's supposed, and then you're supposed to do.
Right. And that's why I want to see it.
Yeah.
And to your point, I mean, let's say just hypothetically that Goulding can prove that they breached their fiduciary duty. Proving damages is going to be a hard thing because she did play events that were, owned and or operated by competitors to Live Nation. And so the argument is like, even if this was in there, pinpoint the times or shows that you didn't get because we said, oh, there's no Live Nation venue here or whatever. I mean, like, that's going to be like a real challenge for proving up damages. In this kind of cases, like, how can you prove that you like lost money because of this? Even assuming arguendo that it's in there.
Well, that's right. Well, that's my next question. There's recovering damages. I mean, what would she have to demonstrate that she had competing offers? Would she have to find competing offers or made the time and then show she wasn't showing them, or like what would that look like?
I mean, and that's the only way to do it is to show that her managers had opportunities to book her in either more valuable places or in times where she wasn't working, and that they didn't do that because of this steering clause. And like, that's going to be hard. Like, maybe there are written offers, maybe there are emails, and that'll all come out in discovery, which is why discovery is such a good thing, is like, we don't know. And, maybe she knows of opportunities. Maybe she ran into someone and said, dude, we tried to book you for this and we couldn't. Like, your agent said you couldn't do it. Like, what were you doing that day? She's like, I was sitting at home. Well, that might be a legitimate kind of like example of where this clause could have come into play. But until we actually kind of see under the hood of like what kind of evidence and documentation there is, then it's just like, I don't know how you prove that unless there are like those kinds of pieces of evidence that would withstand legal scrutiny and evidentiary barriers to being introduced as like legitimate evidence of lost income or damage done to her because of these practices and or clauses in the contract.
Now, like we said earlier, like, Live Nation's not named as a defendant in this lawsuit, but they seem like they have a lot to lose here. A lot to worry about the scrutiny, right? Like I said before, this to me kind of seems like this is the missing antitrust case, right? Like, how much control does Live Nation have through its ownership of management companies, which, according to this article in Variety, and I've done my own research, they manage something like 350 artists through 20 to 30 management companies, right? I mean, how do you think this is how big of a liability is this, you think, for Live Nation, Mike?
I think that it's funny you said that, because that was going to be one of the last points I made on this, and I was thinking about it, kind of preparing for this pod, is this is exactly why, in the points that should have been made in the Live Nation Ticketmaster antitrust suit. But remember, artists were afraid to step forward and come and be participating witnesses in the federal case, probably because of things like this, because Live Nation's monopolistic reach allegedly extends all the way down into their managing agents' contracts. I mean, that's crazy. I mean, this is an example both of why the Live Nation ticket mastering case is so important, but also it shows the amount and breadth and length of their influence in the space. They don't only own the ticketing company Ticketmaster. They don't only own the venues. They don't only own all these things. They own the managers at all of these smaller agencies and stuff, allegedly. Again, this is all just been kind of broken and stuff, but this is prime example of why the artists weren't as involved. Questions that we were asking, during the trial earlier this year, oh, there's not a ton of artists coming forward. Well, they fear retribution, or they have these contractual contracts that they don't even know about that Live Nation has its fingers on or in.
Right, exactly. And it's we really don't have a full accounting of what exactly Live Nation even owns, right? I mean, look at this first. It was interesting, it was difficult to find. If you look at Live Nation's subsidiaries list on its annual financial return, investor report, whatever you want to call it, right? There's no entry for TAP management. That's because they're using some kind of entity to control their interest in that, and that's that HNOE Limited company, right? So it's not clear to find out how many management companies they own. They have subsidiaries that own subsidiaries that own subsidiaries, right? They have companies that own pieces of things that we're not aware of. Earlier this month, we found out that popular online blogs, Brooklyn Vegan and Alternative Press were shutting down, and that those were owned by Live Nation because of Live Nation's ownership in Veeps, a streaming company, which apparently owned these high-profile blogs, which nobody knew about until they were being shuttered, right? And so, even after all this scrutiny, we really don't know what exactly Live Nation owns. And I'm surprised this hasn't been clarified more by legislators and senators, right? Wanting to get
or the Ticketmaster Live Nation antitrust case.
Yeah. Right. I think you're right. I think there's just difficulty finding people standing to take it on, because it's artists who have the standing, and they don't necessarily want to do it for whatever reasons, right? Because artists don't measures. But it's interesting that Goulding would, right? Because I wonder what she really has to gain here, right? I mean, what does she? I mean, financially, right? I mean, we could maybe see the return of some of the commissions she made. Maybe she could argue damages, but it seems like this is more of a structural argument, right? No one's been able to tell me what really she's going to benefit from any of this.
Yeah, I mean, I think it would have to be potential lost business, potential damaging of relationships with other venues and things like that. And it's hard to put a price on those kinds of things. I mean, what you said is they'd have to give back commissions, the remedy, which is called disgorgement. But if they got a commission, that means she got money. I mean, 20% it sounds kind of high to me, and great if you can get it, I guess, as a manager. But like,
Yeah.
They got 20% of what she got. So she got money. She would have to prove that she could have made more money on the same date at a different venue, but didn't because of these steering clauses and their breach of a fiduciary duty to her.
Right.
And, there's like very hard, if not impossible, to get punitive damages in these kinds of cases. So it's like real economic damage that has to be proved. And it's challenging.
Yeah. That's a good point. Well, this to me brings up just like one of the kind of last point I'll see is that like we've seen the rise of the music manager pseudo celebrity, right? Guys like oh my god, why am I forgetting Justin Bieber's manager? What's it? Scooter Braun,
Yeah.
right? And other people where the managers are getting almost as famous as the artist, where managers are creating these management companies that draw on all this outside investment and that the management company itself is a vehicle for outside money, which it should not be. This should still be a services business, I think. And I think this is just one more sign of that part of the business getting out of control and really not really kind of losing sight of what it was originally meant to do.
Yeah, totally agree.
Well, we'll be interesting to follow this one as if we can follow it. Like I said, it's in the British court system, and it's not clear, how we can keep up with this trial, but hopefully enough will leak out so we can keep an eye on what's going on here, and maybe Live Nation will respond. We'll see.
Yeah. Proud of you, Dave. We made it. We did it.
Michael, another week, man. I'm not gonna lie, my tongue feels like it was in a 12-round UFC fight. I'm gonna go
and lost.
I'm gonna go just through bare silence right now, which would be difficult with my kids.
Just count down the days till they're in school. Like I said, ours are in school. It's amazing.
Well, thanks again to viewers for tuning in to an episode of Decibel Docket. We really appreciate you. If you could recommend us to a friend, give us a review, rate us, do the comment, whatever. Just engage a little bit with our show.
Show some love. Absolutely.
And until then, we'll see you next episode. Have a good one, guys.
See you, Brooksy.
You've been watching the Decibel Docket podcast. Please like and subscribe and tell your friends.